Good afternoon, ladies and gentlemen. Thank you for taking the time to be with us today, and welcome to the In-House Counsel Forum program and our eighth webinar in this series. My name is Nidhi Kilawala, and I am a partner in Khaitan's Corporate and Commercial Practice Group. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. Next slide, please. The In-House Counsel Forum program is designed to provide training and education in legal operations, business, management, and substantive law relevant to general counsel and their in-house counsel teams, as well as a discussion forum on contemporary issues relevant to the in-house community in India. Our subject today is Regulatory Enforcement Alert. On this slide is the agenda for today's webinar. In summary, we will have an expert panel discussion followed by a Q&A session with audience questions. We have already received several audience questions, but if you have more questions, please submit them using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will be sure to respond offline by email after the webinar. Also, please note that a copy of the presentation, summary notes of the discussion, and a recording of this webinar will be sent to you after the webinar as a matter of course. The topic for this webinar is particularly important for Indian General Counsel and their team members, as you play a pivotal role in guiding your organizations through the complexities of India's dynamic business environment. Given the rapid pace of regulatory changes, it's imperative to stay informed and equipped to navigate these evolving challenges. Today, we will delve into key areas of regulatory enforcement, including competition law, foreign direct investment, SEBI corporate surveillance, and beneficial ownership. These topics are increasingly critical for businesses operating in India, given the heightened scrutiny from Indian regulatory authorities. We'll discuss recent developments and emerging trends that could impact your organization. Our expert panel will provide valuable insights and practical advice on navigating these regulatory challenges. Next slide, please. Everyone who has registered for this webinar should have received by email already a summary of the panel members and their credentials to talk on today's topic. So I will not spend much time introducing them. Suffice to say that they are all experts in this subject matter and qualified to express their views on these issues. On our panel today, we are joined by my partners Anisha Chand, Tomu Francis, Samir Sa, and Atul Pandey. So now let's start with our presentations. Thank you, panelists, for being here with us today and for giving your time to this wonderful discussion. We'll first start with Anisha Chand. Anisha is a partner in the Competition and Antitrust Practice Group and has been involved in advising domestic and multinational companies on the full spectrum of competition matters, including cartel enforcement, abuse of dominance, merger control, leniency, and competition audit and compliance in diverse sectors. Anisha will spend some time today talking to us about the key trends that have emerged from regulatory enforcement, specifically in the case of competition and antitrust, and we'll zoom in on some of these issues, particularly in connection with technology and digital sectors. Over to you, Anisha, and thank you so much for being with us.
Thank you so much for that introduction, Nidhi. If you can just move to the next slide, please. Right. Very good afternoon to everyone, and thank you for joining in. Indeed, I think for competition practitioners and the Competition Commission of India alike, the year so far has been truly eventful. We've had a host of amendments going live this year, starting with the settlements and commitments regime that's applicable for investigations that came into force earlier this year in March. Followed by the merger control amendments that came to life last month. So I will speak on some of these in the next few minutes, but before that, I think let's just look at what trends we have been witnessing in the last couple of years. So first is certainly enhanced scrutiny of merger cases. Every deal that requires a prior clearance from the commission based on it meeting certain thresholds thresholds needs to go through a rigorous scrutiny by the Competition Commission of India. And what we are seeing is that there are a number of requests for information that case teams issue, and they are not shying away from identifying problems early on and also playing sort of detective to extract more information. Internal documents are being increasingly sought, and it's therefore very, very important that your commercial rationale for doing a transaction and what you disclose to the commission by way of your merger notice is aligned with what your internal documents say. They should not be telling a different story. We also see that there is a lot of inter-regulatory coordination that is happening on a lot of cases, and just in terms of substantive assessment, the commission is more and more keen to come up with narrower market definitions, narrower overlaps, which means that your market shares of the combining parties could turn out to be much, much higher. Connected to this is availability of exemptions. So as some of you would know, there are a bunch of exemptions which are there in now what we call the exempted combination rules. And again, the commission is becoming fairly conservative. If your transaction is not falling within the strict black letter of the law, it is unlikely that they will be amenable to extend sort of a purposeless interpretation to it and grant some sort of an exemption to your transaction. The second would be raising the bar for securing green channel filings. What do we mean by green channel? Green channel is sort of a fast track approval process that was introduced several years ago now and has been very, very popular with financial sponsor clients. It's basically a deemed approval mechanism where if the parties to the transaction don't have overlaps, they can file this simple form and get their approval. There is no waiting period. But what has happened in the last couple of years is that the commission is taking again a much more stricter stance, and with the advent and the enforcement of the new law, the entities that one needs to consider to map overlaps has sort of widened. So every entity in which you have access to commercially sensitive information is to be now considered as an entity with whom you will map a business overlap vis-a-vis the target's business, which means that the possibility and probability of you getting a green channel to begin with is going to perhaps see a decline. Like I said, there have been a lot of amendments. A consequence of that is there will be a lot more engagement with the commission to seek their views or through a pre-filing consultation facility. We've got the deal value threshold, which introduces a number of concepts like the deal value itself, the gross merchandise value of an entity, whether it is substantial business operations. So lots of new concepts have been introduced, and this means that the parties will probably need to approach the commission more often than not to seek some guidance until there is clarity and some sort of additional guidance being introduced. And lastly, what I have for you is the penalty on global turnover. So for investigations for antitrust practices or abuse of dominance, if there is a violation, the company who is found to be in breach is liable for penalties which could be very, very high. And now the base for the penalty has been expanded to include global turnover from the infringing products or services in question. But the good news is that simultaneously there are also penalty or fining guidelines that have come up which sort of temper down and explain the manner in which the penalty needs to be computed. You need a relevant turnover, which is based on the revenue derived from the affected products. And there could be a base penalty and mitigating factors that can be looked at to sort of further reduce the penalty implication. Next slide, please. So like I said, going forward, what are the key areas to watch out for? First is, like I said, a number of your ongoing transactions or the transactions that you're looking to do in the coming months could be affected by the new deal value threshold. It's been notified effective 10th of September. And where a transaction value exceeds 2,000 crores or roughly about 240 million USD or 218 million euros, and where the target enterprise has substantial India operations, your deal might attract CCI scrutiny, and therefore it's important that you consult with your antitrust counsel and see whether you're eligible for some exemption or you need prior blessings from the commission. More particularly, if you're doing deals in the tech space, the thresholds are comparatively lower and also distinct from non-tech businesses. So it's certainly a watch out area for companies who are engaging in transactions in the tech space. For financial sponsor deals, again, two important things. One is there have been certain revisions in the exemption, which is again popularly called the solely as an investment exemption that most financial sponsors like to avail of. There are changes in the wordings of the exemption. The criteria has become stricter. Again, if a private equity fund has access to commercially sensitive information, comparatively sensitive information, then that's an entity that will become relevant from an overlaps perspective and might have a bearing on eligibility for your green channel approval as well as eligibility for your exemptions. The last but not the least is something that we're all riding on, the tech bandwagon. There are a number of investigations that are ongoing against the large big tech companies. We expect in the coming months that some of these will be concluded and certain first principles will be established, and that will have a bearing in on the cases going forward. There is also the digital competition bill, which is being deliberated currently to regulate the behavior of large tech companies. And you know, these are, and last but not the least would be the market study that the commission has launched in relation to artificial intelligence, that hopefully will be very insightful and reveal probably the mind of the commission going forward so far as AI is concerned. I will take a pause here and hand it back over to Nidhi.
Thank you, Anisha. That was extremely interesting. You mentioned, Anisha, that the settlements and commitments regime is also now in force. Can you explain to our audience its significance and relevance, especially for parties that are facing investigations?
Yeah, thanks, Nidhi. So, yes, this is a completely new regime. Commitments and settlements by definition means that these are avenues where which parties can avail of to be able to quickly close and reach finality to their investigations. So commitments is something where you are undergoing an investigation and the commission has come up with a view that this needs prima facie, this behavior or practice raises concerns and therefore it needs to be fully investigated. Parties are free to give commitments in the form of behavioral remedies or any other sort of commitments which allay those concerns that the commission has come out with, and there is no admission of guilt. And similarly, settlements is something, so once the prima facie view of the commission is out, there is an investigation by the director general, and if the director general's report is also negative, the parties are free to then offer settlements, which is similar to commitments, but you can basically address all the concerns in a timely manner and then you're bound by it. You can't appeal that order if the commission also accepts those commitments and settlements from you. So we think that this is going to be a good trend. In fact, Google has already filed a settlement application in one of its ongoing cases in the TV Android segment. So it'll be interesting to see whether the parties are actually using this as a bargaining tool to their advantage to you know, end the litigation processes and reduce their own and the commission's effort and time in investigations.
Super helpful. Thanks for that, Anisha. I think another key point that our audience would probably benefit to hear from you on is, you know, it's interesting to hear about what all the different areas of enforcement are currently from a merger control and antitrust perspective. But what is really, like, what does the Indian merger control regime prescribe in terms of penalties for, say, non-notification of a reportable transaction? And how does this really play out in practice?
Yeah, no, that's a brilliant question. Thanks for that, Nidhi. So there is, the law says that if you don't notify a reportable transaction or you have partially consummated a deal while your CCI review is still pending, you are liable to very high penalties, which could be up to 1% of the combined assets or turnover of the merging parties or the transacting parties, whichever is higher. Now, that's a very high number, but in reality, what we see is that the commission is certainly very high on enforcement. Gun jumping penalties have been on the rise, and something that is, I think, also serving as a deterrent now. But just if I have to give you a number, I would say on an average, in the last 2 to 3 years, we've seen a maximum penalty of 1 crore, which is 133,000 USD. So the commission is actually taking very active steps to even send notices after their media scanning to parties to see why did you not notify this deal. We believe that it should have been notifiable. So it's a show cause and it's a full proceedings, and you have to convince them as to why you were eligible for an exemption and why you didn't require a prior notification. So certainly the commission is very active, and it's showing through all the number of penalties, including the quantum of penalties, which are clearly on the rise here.
So very interesting to hear that the commission is not just, and the laws are not just, providing for digital advancements in businesses that they regulate, but also using digital tools for, enabling regulatory enforcement. So that's a very interesting note to end on. Thank you so much for that, Anisha. I will now request our next presenter, Tomu Francis, to step in and discuss SEBI-related enforcement and key issues that we have been seeing so far. Tomu is a partner in the Dispute Resolution Practice Group in our Mumbai office. Tomu specializes in securities litigation and related advisory matters. Tomu's expertise lies in advising various intermediaries associated with the Indian securities market and assisting Indian listed companies and their promoters on regulatory and investor concerns. He regularly appears before the Securities Appellate Tribunal on various contentious matters. And thank you, Tomu, for joining us here today and sharing your thoughts with us. Over to you.
Thank you, Nidhi. Thank you for the introduction. Good afternoon, ladies and gentlemen, and thank you for tuning in today. So, over the last 7-8 years, possibly 10 years, the markets have substantially increased. Over the last 10-year period, the CAGR of Nifty has been over 10%, and in the last 5 years, over 16%. And the last 5 years includes the COVID period. So in effect, what it means is that last 3 years there has been substantial movement in share prices, substantial participation by retail participants. In fact, there are SEBI reports which say that the participation in the retail markets have gone through the roof and have been at an all-time high for the last couple of years. Also, the number of demat accounts, which indicates participation, has again is at an all-time high, and therefore participation by all stakeholders is very high. In terms of on the other front, there is also this whole aspect about SEBI coming out with reports saying that the retail investors are losing money. So, as a crux, what is the reaction of the regulator? The reaction of the regulator is also that of a hyperactive regulator, because there is hyperactive activity in the market. Now, in terms of reaction, there are only two reactions possible. One is on the policy front and the other is on the enforcement front. We will talk more in detail about the enforcement front in this presentation, but even on the policy front, it operates on two parts. One is substantial amendments to the regulations, by which it operates on a larger front, and by circulars when it appoints and makes changes in terms of special operating activities. Now, what this has essentially meant is that there is increase in participation that has resulted in increase in fraudulent activities, and thereby resulting in further regulation by the regulator. The three areas that we have seen recently that has taken a lot of interest in respect of identified buckets is: one is insider trading, one is fraudulent and unfair trade practices, and balance sheet frauds. There are also certain additional elements under disclosure regulations under LODR. Now, in terms of insider trading, the regulator is looking at if somebody is misusing insider information to take benefit of such information that is not available in the public domain. Under fraudulent and unfair trade practices, the regulator is looking at whether market participants are manipulating a particular stock. In terms of disclosure requirements, SEBI is looking at whether disclosures are appropriate, inappropriate, or whether adequate at all or not. In terms of balance sheet frauds, which is fairly new, it is looking at specific events in terms of related party transaction, siphoning of money outside the company, and misrepresentation in balance sheet. As a consequence of all these investigation has resulted into a larger foray into enforcement orders being passed. As a result of that, there is also an increased element of settlement proceedings being applied for. When settlements are being applied for, the recent trend is that in larger and more complicated matters, the settlement amounts being sought after by SEBI is significantly higher than what it used to be in the past. There is also a new trend in 11B matters, that is the more critical matters, that SEBI is asking for voluntary debarment, voluntary restraint of trade in the market, and voluntary restraint from raising capital. So in terms of all of these, the stakes have become higher over the last couple of years, both in enforcement as well as in settlements. Now, disclosures as a element of how investigation starts, and the aspects that I highlighted before, be it insider trading, be it PFUTP, be it balance sheet frauds, these are all the underlying element is that of disclosures. By disclosures, SEBI requires companies to come out and make disclosures so that all relevant information is available to all participants. Now, being a disclosure driven regulation, the aspects of not disclosing or giving wrong disclosures is at the heart of all other investigations. Next slide, please. I will take you through a specific example which highlights how these information is being looked at by SEBI. Now, if you look at this example, there is a disclosure by a company on a particular day where it discloses that a certain other company is investing into this company. Now, what has happened, if you look to the chart on the right, if you look at the part that is highlighted, on the day that the disclosure was made, the price has increased. So a couple of days prior, the volume has increased, the price has increased, and therefore, and it culminates on the day of the disclosure. Pursuant to that disclosure being made, there is a fall in price. That means that there are participants that have looked at this information that was available to them prior and have taken action on that. These type of matters are likely to be investigated by SEBI. Next slide, please. We also took a deep dive into the kind of investigations that SEBI has done over the last couple of years to see out trends in how things were progressing. From the year 2021 to 2023-24, there has been a significant increase of over 141% in terms of the matters that have been investigated. Now, from 2020-21, the corporate finance frauds, which is the light orange number, which was 3 in number, now has increased in the last 2 years to 32 and 34, which also marks a significant deviation into the focus areas of SEBI. In this regard, I would also want to spend some time on the corporate finance fraud aspect of it. Next slide. So in terms of corporate finance fraud, what it means is that a company's financial statements are being misrepresented by the company. Some of the parameters of how it is done is that by inflating or deflating asset values, or understating liabilities, or in fact misrepresenting financial performance indicators that is put out into the market. Now, when that is done, it portrays a wrong picture of the company's financial health, which in turn influences certain people to take investment decisions in a particular manner. Now, SEBI has looked at this area as a focus area for the last 2-3 years, and a specific department has been created for it. And this department, in deviation with past practices, have been passing drastic orders. Some of the examples that we are putting across are in fact the RHFL matter, where SEBI has gone ahead and put across a fine of 625 crores, which is in deviation and possibly one of the largest penalties that has come till now. In this matter, there was a siphoning of monies from a listed company to other related entities. Similar is the matter for Omax, where it was a question of aggressive accounting. In the matter of Binny, in fact, there was a law firm, the order directs that a law firm be taken on record so that they can recover the monies that have been taken out by the company and its promoters. So these are the drastic measures that are happening in this area. And as a summary, I would like to just say that SEBI is looking at things very differently these days. They are looking at more critical matters, and as a consequence of which, the stakes involved for a company and the promoters are higher. And this can be effectively managed if it is managed right at the beginning, at the stage of investigations, rather than post the issuance of show cause notice. Thank you. If you have had, I hope you've had a insightful session. And if there are any further queries, I'll be happy to take them.
Thank you for that, Tomu. It was super informative. If I were to ask you what is, or what are the areas which are getting the most attention from SEBI right now, which also have the most serious consequences for a listed company, what would that be?
So in terms of all the aspects that I've highlighted in terms of insider trading, fraudulent and unfair trade practices, and balance sheet frauds, all of them have been very critical. The test is the aspect of whether a 11B proceeding is initiated or an adjudication proceeding is initiated. In both instances, what happens is there's a monetary penalty only in one kind of proceedings, and the consequences in 11B are debarment, disgorgement, and penalties, which is consequently much higher stakes are involved in 11B proceedings.
Got it. Very clear. Thanks for that, Tomu. And I guess another relevant question would be that what can public companies do better to deal with investigations by SEBI with respect to breaches of the LODR? Is there something that you would want to leave with our audience in terms of how they can sort of say tweak internal processes or any of those things to make sure that they're avoiding breaches of the LODR, and in case they are looking at an investigation by SEBI in this regard, then how do they deal with it?
So bookkeeping has become very important in terms of how records are kept. There are PIT related matters which SEBI has in fact gone after companies for not maintaining SDDs. So in terms of maintaining SDDs itself, that's the bulwark or the basis on which an investigation is being conducted. So in terms of even the process, the moment one receives a query from the regulator, it is always better to drive home the narrative from that stage rather than appointing advisors post the issuance of a show cause notice. We need to be very clear on how we are responding to queries, initial queries that are received from the stock exchanges and SEBI. That becomes the basis of your larger reply or larger proceedings once they initiate.
Super useful. Thank you so much for that, Tomu. And thanks once again for being with us here today. I'll now request our next presenter, Samir Shah, to share with us his thoughts. Samir is a partner in the Corporate and Commercial Practice Group in our Mumbai office, and Samir specializes in the areas of strategic M&A, joint ventures, collaborations, foreign investments, private equity, and other such investments into India. Samir has played a key role in procuring certain regulatory approvals for investments in India, specifically in pharmaceutical, healthcare, retail, and franchising sectors. Thank you, Samir, for being with us here today. Over to you.
Thank you, Nidhi, and it's a pleasure to be here. Next slide, please. As some of you may be aware, most countries have beneficial ownership registries where details of beneficial ownership of entities have to be reported. In continental Europe, we see UBO disclosures, whereas in the United Kingdom, persons exercising significant control over companies need to report themselves to the Companies House. So this should hopefully be very commonplace and consistent worldwide. But that's where India does it a little differently, because the way we determine beneficial ownership tends to be a little different. For a very long time, India didn't have such a registry, and it received continuous and scathing feedback from the Financial Action Task Force for this. Eventually, by an amendment in 2017, certain significant beneficial ownership, or SBO, filing and disclosure requirements were introduced in the Companies Act. Mind you, and I stress this again, These are different from how ultimate beneficial ownership is disclosed to banks and other financial institutions as a part of the KYC guidelines of either RBI or SEBI. The principal optical difference is that these new filings are publicly available on the website of the Ministry of Corporate Affairs. However, the otherwise more discrete UBO filings are not publicly available and are made with banks and financial institutions. The rules that were applicable to companies were first introduced in 2018, but they met with stiff market resistance due to several aspects being unclear. As a result, these rules were overhauled and reintroduced in 2019. Eventually, the rules applicable to limited liability partnerships were also introduced in 2023. As I mentioned, the method of determination of UBO or ultimate beneficial ownership is different from how SBO determination is done. The rules cover multiple categories of shareholders, including companies, partnerships, trusts, something very specific to India, the Hindu undivided families, etc. In terms of reporting timelines, while there was a transition period initially, there is a requirement to report each time there is a change. Also, companies have been charged with an oversight obligation to continuously maintain diligence and ensure that they keep watch on who their SBOs are. The same obligation applies to limited liability partnerships as well. In this calendar year, various registrars of companies have been chasing companies for whom no SBO filings have been done, and they have all received notices. Where the registrars have not been convinced with the reasons and explanations, they have also been imposing penalties on Indian companies, their directors, suspected beneficial owners, and all people concerned. Next slide, please. Two cases which are interesting to see are those of LinkedIn and Samsung. The challenge is that there is a set of objective criteria for determining SBO status, but there is also subjective criteria involving the determination of the ability to exercise significant influence or control. Any individual having the ability to exercise significant influence or control is required to report themselves as a significant beneficial owner of the Indian entity. These terms are highly fact specific and covered by inclusive definitions which are capable of being interpreted as well as misinterpreted. In LinkedIn's case, LinkedIn India is indirectly owned by LinkedIn US, which is indirectly owned by Microsoft US. Based on the objective criteria and their own determination, no filing was made. However, during the show cause and adjudication proceedings, the authorities noted, amongst other things, that the directors of LinkedIn India were actually employees either of LinkedIn or Microsoft, and therefore, technically, they would be obliged to adhere to whatever instructions either the LinkedIn US CEO or the Microsoft US CEO would provide to them, their duties as fiduciaries of the Indian company notwithstanding. This and other similar facts led the authorities to conclude that based on potential ability to exercise significant influence, the chief executive officer of Microsoft Corporation and of LinkedIn US should have reported themselves as SBOs. So far as Samsung is concerned, the authorities recently evaluated two subsidiaries of Samsung in India. Neither of them had reported any significant beneficial owners. But basis public domain, the authorities found that the executive chairman of Samsung Electronics, the parent company, held minority shares but was nonetheless appointed as the executive chairman of the parent company. Therefore, there was an element of influence somewhere, and as a result, there ought to have been a filing in India for the Indian subsidiaries, and the subsidiaries had defaulted in their obligations. Both orders make the entire shareholding structure public as well. Therefore, to summarize, companies need to continuously evaluate their beneficial ownership filings. They need to sensitize all shareholders and stakeholders that the minute there is a change, whether direct or indirect, they need to evaluate the impact on that change on their existing filings. Even otherwise, authorities are increasing enforcement, including imposition of penalties, not to mention the disclosure risk, because all of this information is available in public domain. With that, let me pause here. I will hand it back to Nidhi to continue the webinar.
Thank you for that, Samir. I think it's very interesting when requirements like this are brought about by legislative and regulatory changes in any market, because it's really like trying to balance the requirements for demanding transparency or corporate transparency, but at the cost of piercing the corporate veil. And how do stakeholders really navigate that, I think, is a key item that one must bear in mind while A, making investments in India, and B, continuing to make these disclosures on an ongoing basis. So thank you so much for drawing our attention to this requirement and also the enforcement, which has significantly gone up over the last couple of months. I think one question that Samira audience would like to hear from you on is, how does this really play out in the context of, say, pooled investment vehicles? I think the examples we all spoke about are subsidiaries of large corporations. And in some ways, maybe it is clear to establish a chain of control or title, of course, keeping in mind all the tests that you just highlighted for us. But when it comes to, say, private equity funds or other similar financial investors, how should they think about these significant beneficial ownership related disclosures? And what is it that you would say they need to be aware of such that they don't, inadvertently fall foul of these requirements?
I think that's an excellent question, Nidhi. And I would say there are three things to consider. The first and the most important aspect is, if there is a financial investor who is otherwise registered either as an alternate investment fund or as a foreign portfolio investor, helpfully so, their shareholding is exempted by the rules. If, let's say, that is not the case and they're investing through on an ordinary basis, and they can demonstrate that they are investing through a pooled investment vehicle, and the pooled investment vehicle is located in a jurisdiction which meets certain requirements, then rather than going back to the people who hold the economic interest, i.e., their investors, one would look for the individuals who are either the general partners or the investment managers, or individuals who are holding the designation or functional purpose of a chief executive officer. If that also is not available, that is when these investors are also open to the vagaries of who in their ecosystem exercises significant influence on the eventual Indian investee company, or in the case of buyout or control funds, are they in a position to say that they exercise control on the Indian enterprise?
Thank you for that, Samir. Very clear. And I guess one last question before we move on is, would you say this is localized to, say, the Companies Act requirements or the SEBI disclosures, as Tomu just spoke about? Or are you really seeing some of these significant beneficial ownership norms being used in other regulations or legislations in an Indian context?
Well, that was the belief, Nidhi, when these regulations came about, because as I said, it felt as though it was being done clearly to take care of the international criticism. But over time, we are seeing more and more government agencies are getting comfortable with these arrangements. So, as I mentioned, these were introduced in 2019. In 2020, and Atul will speak more to this, we had the Press Note 3 being introduced, which also captures the term of beneficial ownership, but without any definition. Who's to say whether this definition applies there or not? In addition, what we are seeing is the banking regulator, the Reserve Bank of India, when it comes to evaluating applications for investment in banking companies, they are borrowing concepts from the significant beneficial ownership rules. So clearly, different arms of the government are getting comfortable from a policy perspective that these rules will help. And therefore, we only see this net being expanded, whether it is the core concept of significant beneficial ownership or borrowing bits and pieces and using them in another context.
Thank you so much for that, Samir. I think that's an excellent segue into our next presenter, which is Atul Pandey. Atul is a partner in the corporate team and has been advising on corporate and commercial issues, regulatory matters, including under India's foreign exchange control regime, the FDI policy, and has played an instrumental role in obtaining several approvals, especially in the context of the ultimate beneficial ownership regime that has now been introduced in the context of the Indian exchange control laws. So Atul, thank you so much for being with us here today, and over to you.
Thank you, Nidhi. Good afternoon, everyone. So, next slide. As we know that India is a hot destination when it comes to foreign investment. So with the increased foreign investment, we have also seen that there are compliance issues and also there are investigations with respect to those investments. And there are several regulators who actually regulate foreign investment in India, specifically Department of Commerce through DPIIT, Reserve Bank of India through various filings are being made. And in addition to that, the Reserve Bank of India also has its investigating arm, which is Directorate of Enforcement. And lastly, of course, all of them are being governed by Ministry of Finance. So what we are seeing is that these regulators are playing an active role in terms of scrutinizing and kind of issuing notices and to investigate any kind of violations with respect to foreign direct investment. What we are also seeing is that there is a lot of exchange of information within the department. So, for example, if you have made a filing to Reserve Bank of India, automatically, if they feel that there is a violation, they may either write to the Income Tax Department or they may write to their investigating arm, which is Enforcement Directorate, and they may also write to other sector regulators, depending on in which sector the Indian company is operating. So, very important to identify the regulators and from where the notice has been issued. What are the key trends which we are seeing in the regulatory scrutiny process by these regulators? Of course, one is they are looking into the structures which had been created for these investments, either inbound, which is foreign investment, or outbound when you actually make a overseas direct investment. So the focus is purely on cross-border investments and those structures, whether those structures are being complied with the applicable laws. In addition to that, we have also seen because remittance from India is freely allowed under foreign exchange laws. So, under what manner and what is the nature of those remittances? There is a scrutiny around that. So, for example, if the money is being remitted from India in form of license, technology, any kind of service arrangement, and what is the backing or the underlying document, that is what these regulators are looking at. In addition to that, we are also seeing government is basically tightening or in a way creating or imposing new conditions with respect to foreign investments, either inbound or outbound. And in that process, there are certain policy changes which had taken place. For example, we have new overseas direct investment guidelines, which not only just govern investments abroad, but also any kind of investments which is being round trip back into India or otherwise. Uh, in addition to that, under the foreign direct investment policy itself, there had been certain changes in order to make sure that all these applicable rules are being complied with. So, for example, there is a standard operating procedure which Government of India had laid down last year, just to identify who are the beneficial owners, etc. Now, when these regulators are actually investigating, what are the key factors? What are the things which they are actually investigating? What we have seen in all these investments or any kind of structure which had been adopted, the first question is if there is any applicability of Press Note 3, which was issued 4 years back. And Press Note 3 is actually applicable in relation to any investment coming from China and Hong Kong, particularly, but the language suggests that any investment coming from a country which shares land border with India. So Press Note 3 applicability is important to make sure that security angle and national interest is being protected. Also, a regulator is looking at any kind of non-compliances which had taken place in the company with respect to their previous investments. So non-compliances are also being looked into just to make sure that these are rectified. Also, they are looking at valuation to make sure that there should not be any money laundering, kind of aspect which is being involved. Then every sector in which investment is coming is also having sectoral conditions, and many times we see that sectoral conditions have not been complied with. So from that perspective, government or the regulator looks into to make sure that these sectoral conditions have been complied with. Also, investor KYC, which is important to make sure who is the ultimate beneficial owner, what is the management of the investor, and if there is any security risk with respect to those investments. So these are important aspects with respect to any FDI investigation. Next slide. Yes. Now, as I mentioned, Press Note 3. So what is the key factor and what we are seeing from government's perspective? Of course, in terms of Press Note 3, the most important aspect is national security. And from that perspective, security clearance is required. So what Ministry of Home Affairs or Ministry of External Affairs, these two important ministries are looking at is the background of the investor, the management, to make sure that the investment is not in a way a red flag for Indian economy at large. Lastly, the sensitivity of the sector, which is important, in which sector the investment is coming. For example, certain sectors have been categorized as sensitive sector, for example, defense, telecom, broadcasting. But over the course of time in last 2-3 years, we have seen that even financial services sector as well as sectors where data is involved, even they have been categorized as sensitive. So government is looking, if the investment is coming in a sector which is sensitive, then increased scrutiny and kind of regulatory background check is being done. Past investment by investor, as I mentioned, because sometimes the investor is already having an existing investment, and in order to make sure that they are fully compliant, the previous filings, etc., is being checked to make sure that there should not be any, unregulated kind of non-compliance being taken place. Lastly, government is also looking at benefits from those investments, whether such investment is creating any kind of ecosystem, any technology is being basically driven. Also important to see how it is helping generating employment at large. And in that process, government is of course kind of checking the transaction. uh, they are kind of looking at the underlying documents through which these transactions are taking place, any of the structure which has been adopted, whether such a structure is in compliance with Indian law and not to bypass any of the applicable laws, including Press Note 3, and of course, who is the UPO. And what we are also seeing is that if government finds that there is a violation, then there are two courses of action. Number one is either they are asking to take post-facto approval to regularize such investments, or kind of asking them to go for compounding. And in many cases, when enforcement directorate is actually investigating, they are trying to impose maximum penalty under the law. Of course, it is up to 3 times, but there is a discretion which has been given to the regulator, both to the enforcement directorate and RBI, and they are using that discretion. Next slide. Uh, in that process, some of the recent cases, of course, these are in public domain, so we thought it would be appropriate to kind of highlight what are the issues in these cases. And of course, this ties up to the fact which I just highlighted from a regulatory scrutiny perspective, what government is looking at. So, for example, Xiaomi's case is quite popular and has kind of created negative sentiment when it comes to investments from China and Hong Kong, and of course, wherever there is a Chinese UBO involved. What government had actually alleged that Xiaomi is actually remitting the money from India, or in a way siphoning off the money from India under the garb of license and royalty agreement, where there is no actual technology or license which has been given. And in that process, they actually seize the bank account and stop the operations of the company for a certain period of time. And so government was, of course, looking into the remittance mechanism and kind of trying to allege that there is a siphoning off of money in violation of foreign exchange laws. Likewise, in Oppo and Vivo case, there are several regulators which were involved, but primarily it was Enforcement Directorate and Department of Revenue, Income Tax Department. They were basically labeling that these entities were actually remitting the money in form of service arrangements or license arrangements, when again this is purely to kind of siphon off the money from India and has nothing to do with the actual business operations. And in that process, they were also investigating a number of entities which had been created to kind of make these investments through various jurisdictions. Likewise, PC Financial Services, which was a registered NBFC, and it was like a quick lending app in India, which was quite popular. So their business practices were investigated. Again, government thought that probably, through the license arrangement, service arrangement, they were actually siphoning off the money from India. And in that process, they actually seized their bank account. Lastly, one very important case I would like to highlight from foreign investment perspective. See, as in terms of the process, if government finds that there is a violation, they actually ask for a post facto approval and get it compounded. Earlier, the market view was the compounding should be limited only to the extent of money which is involved with respect to such contravention. But in this case, when a large private equity fund which invested in India in a pharmaceutical company, there were Chinese investors also limited to a certain amount, but Reserve Bank of India tried to impose penalty not just on the Chinese investment amount, which was basically the amount in question, but to the entire foreign investment amount, which means that even those investors which were not from China and Hong Kong, even that money was taken into consideration for deciding the penalty amount from a compounding perspective. So in summary, of course, with increased foreign investment, government is more active and trying to make sure that the applicable laws are being complied with. What we suggest is that it is important, if you are approaching to any of the regulator or if there is any foreign investment involved in the entity, it would be good to make sure the house is in order by virtue of comprehensive due diligence of the applicable laws. So I hope this was useful. Happy to take any questions, and Nidhi, over to you. Thank you.
Thank you so much for that. That was extremely useful. Um, Uh, Atul, one quick question is, you mentioned some of these things and that the regulator is becoming more active also because India is now becoming a hotspot for attracting foreign investment. So this is naturally going to follow all the attention that India has recently been getting. But are there any safeguards or good practices that you think can be adopted by Indian companies, especially where they have transactions regularly in case of payment or receipt of foreign exchange, whether it's with respect to their business dealings, like say import and export, or licensing, or any consultancy arrangements? Like, what would you say are good practices that should be adopted by such companies?
So what we are suggesting, Nidhi, in most of the cases is that to make sure your house is in order, and how you can do it. So what we are suggesting at the first step itself, just evaluate all your arrangements through which you are actually remitting the money from India. Make sure that there should be proper documents. In case if transfer pricing is applicable, then make sure you have transfer pricing report from a Big Four. In addition to that, we are also making sure that if arm's length transaction kind of practice is applicable, then of course make sure that it is at arm's length. Similarly, applicable clauses should be provided in your arrangement to make remittance from India. Also, whenever you receive such notices, immediately conduct some of the due diligences with respect to those issues which are being asked, or you have to identify where this investigation is leading to. So what we are suggesting, make sure your house is in order, do a background check, make sure you have transfer pricing reports, as well as arm's length transactions conducted, backed by board resolutions, etc.
Got it. I think super clear. And I think one other important question, and I'd be amiss if I didn't ask, is what is really the consequence of some of this heightened enforcement action, right? So how bad does bad really get? And if there is, say, an enforcement directorate related investigation, would that result in any risk of, say, seizure of assets or unwinding of any particular transactions? Or are we really talking about imposition of just the penalties?
I think this is very interesting question. Reason being, how bad it is bad, it depends upon which regulator is actually issuing the notice. So for example, if the notice is being issued by Enforcement Directorate, then of course you have to adopt a different course of strategy versus say if the notice is being issued by Reserve Bank of India or maybe your other sector regulator. So it depends upon who the regulator is. Specifically in case of Reserve Bank of India's notice, what we have seen, it's mostly leading to violation of foreign exchange laws, and probably it could be civil in nature. So what we suggest is that make sure your house is in order. You do some kind of diligence and then approach to Reserve Bank of India and kind of plead guilty on your own and get this regularized through a compounding process. There is a discretion provided to the officers of Reserve Bank of India, and they of course try to be liberal in case if the violation is inadvertent or kind of unintentional. But when it comes to Enforcement Directorate, reason being because they also look strictly from a prevention of money laundering act perspective, so they tend to take slightly harsher view. And in that case, we have seen they imposing penalty to the maximum extent, while law provides up to 3 times. They tend to go up to 3 times also in many cases because of the prevention of money laundering angle. But it's not just confined to the Indian company. They also try to implicate the shareholders, the management, the directors, and in some cases even to ultimate beneficial owners also. So therefore, my suggestion would be whenever you receive notice, please try and understand what could be the reason for this notice. Just do the homework first, reach out to your consultants, do some kind of diligence and compounding if applicable, and then accordingly, respond to those notices. And one last important aspect from an investigation perspective is, even if you have been called out a short notice by any of these regulators, and you feel that you have given a statement which may be detrimental to the company, just make sure it is retracted immediately, because if there is a delayed retraction, then I think it would be very bad to tie up to your original question, how bad it could be.
Got it. Very, very interesting. Thank you so much for those very specific and pertinent takeaways. Um, Members of the panel, if I could request you to switch on your cameras once again. I think it's been an extremely insightful and interesting discussion. And thank you very much for making the time to be with us here today and sharing your thoughts so candidly. Um, I hope our audience enjoyed it as much as I did. I'm going to take a few audience questions right now, which we've been receiving through the course of the webinar. We've picked up a few along the way when I came in with a few questions, but there are still a few left. So just conscious of time, but I'm going to make this quick. I think the first question we have, and Samir, my question is to you, is how frequently does a company need to approach the SBO confirmation for their holdings or change in holdings? Is there a certain frequency with which this is expected, or is this a one-time filing?
That's a great question, Nidhi. And the law, unfortunately, doesn't specify a periodicity. A lot of it will depend on the facts and circumstances and how glacial or inertial is your shareholder base. So let's say if you're talking about a shareholder base where there are frequent changes that happen at the top, I think it would be worthwhile for the company to confirm on a 6-monthly basis or even a quarterly basis in the absence of a significant beneficial owner. But let's say if it's a very patient long-term shareholder, or let's say if you are a 100% subsidiary of a very large group, then you know that at the large group there may not be that frequent changes. Even if there are, stakeholders will be sensitized to proactively report themselves. So it's a very customized situation, but we would say at the very least renew your declarations and your chasers on an annual basis. But it's a function of how stable and how patient is your shareholder base.
Got it. Thank you for that. The next question is to you, Anisha. How is the Competition Commission of India responding to emerging concerns in digital markets and, say, with respect to e-commerce platforms? I think you alluded to some of this when you spoke about the new amendments that have come through, but I think it's a very interesting question given everything we're seeing right now.
So e-commerce has been a hot space. And the commission has been receiving a number of complaints, I'd say, for the last 6 to 7 years, if not more. The initial stance of the commission was very, I would say, liberal, and a lot of investigations were actually closed because the commission took the view that India is a very nascent market, it's a growing market, technology is evolving. So until things stabilize, people or entities which appear to be dominant today may not necessarily remain dominant tomorrow. So it is not the right time to interfere with these markets and let them evolve. Fast forward 6-7 years, the commission seems to feel that it missed the bus back in the day, and now there are a number of, again, live investigations which they're looking at. They are re-looking and re-evaluating their market definitions to see, just to give you a simple example, online e-commerce markets and offline brick and mortar, shops were seen to be interchangeable at one point in time, but now they are not, which means your market definition has changed, which is why, a lot of these players, big tech players, are coming into scrutiny. So one way that the commission is upping its antennae is really by investigating all of these companies much more and taking more proactive action by not only acting on complaints, but also suo moto taking up cases based on what it believes could be anti-competitive. So that's one tool that it is using. The other tool is the legislative tool. So we spoke about the digital competition bill, and there is Europe, which has already pioneered this by coming up with a law that regulates behavioral or certain anti-competitive practices of large big tech companies, which satisfies certain quantitative and qualitative thresholds. So and there are lots of other jurisdictions which also believe that big tech players, after they reach a certain size and scale, are able to completely tip the market in their favor, and everybody is looking at different ways of regulating that behavior to promote competition and to keep markets contestable. So India has also joined that bandwagon and has come up with a digital competition bill that is going to that's going to basically again have certain standards and parameters. If a tech company satisfies them, then there is presupposition that it has market power, and then there are certain prescribed do's and don'ts that or protocols that it needs to comply with and adopt in its business practices to make sure that the markets, like I said, remain fair, contestable, and the markets remain competitive. So these are the two ways in how the Indian antitrust authority is trying to tackle challenges in the tech space.
Thank you, Anisha. Very, very insightful. I think my next question is for Tomu. I think taking a leaf from what Anisha just said, I think the question is kind of similar. But in terms of how you're seeing regulatory developments, specifically in the context of, would you say that there have been changes in the corporate governance framework regarding responsibilities and potential liabilities of directors, especially from an LODR perspective, like we just heard from a competition commission perspective as well, when they're noticing that there are all of these new age businesses that have now come up the curve, and it's necessary to regulate businesses like that, which were otherwise not within the net. From your lens, we're seeing some of those companies now rush to the Indian stock exchanges for the purposes of listing. So are there any changes that you're seeing from an LODR standpoint for companies that are listed, and especially in the context of corporate governance for nominee directors on the boards of such companies?
So I think that increasingly what happens is that initially there used to be only companies that used to be looked at by the regulator. Now, once listed in terms of misstatements in prospectus, that's a separate category in itself. Uh, in terms of disclosure, continuous disclosure requirements, whether the company is making adequate disclosures or not, and maintaining bookkeeping is all coming down to either the compliance officer or the managing director. So recently we have had a case of Infosys where Mr. Salil Parekh, there was a settlement that he had to undertake because of certain non-compliances. So in terms of how investigations proceed across the board, there seems to be a commonality between what Atul said, what Anisha said. But yes, increased regulatory oversight is something that we are going to live with. That goes to the company, that goes to the directors, and there have been some instances where even the non-executive directors are being asked questions by SEBI as to their roles on the boards.
Thank you for that. I'm just conscious of time, and I'm going to take one last question, which is for Atul. Um, Atul, this is a very interesting question, and I'm eager to hear your thoughts on it. So what we have here is how predictable or consistent is the regulatory enforcement across various sectors in which foreign investment is being received? Are you seeing some sectors get more love from the regulator compared to others?
So see, Nidhi, internally there is a standard operating procedure which has been laid down when it comes to either processing FDI approvals or kind of conducting investigations around that. So to that extent, yes, there is a parity, and of course they try to follow that SOP. But what we have seen is it is also dependent upon officer to officer. So every department have different officers. So it depends what is the nature of the scrutiny and what kind of allegation or contravention is taking place. So whether it's a sectoral condition which is basically falling within the domain of the sector regulator, or it's strictly foreign exchange violation which is falling within the domain of Reserve Bank of India and Enforcement Directorate. But as I just mentioned, because the ambit and role is different. ED's role is to look into prevention of money laundering aspects, whereas RBI's role is to make sure that compliance with foreign exchange laws are in order. So therefore they take that kind of a stand. But having said that, there's definitely a SOP, and accordingly they follow. When it comes to process, they follow the same, but when it comes to imposing penalty, they of course kind of take a view depending on the perspective in which they are actually looking at.
Super helpful. Thank you for that. I think it has been extremely thought-provoking event, and to me, some of the key takeaways from today's webinar, and I think Tomu summed it up really well in his answer to the question as well, is that the common theme across all our presentations today and across all the different topics we've touched upon is the fact that heightened enforcement is here to stay. It is the result of the growth of Indian businesses and digital advancements, and it's probably the way of the future as well. So I think one way in which in-house legal teams can help to manage risk on this account is to be aware of these risks and simply preparing in advance. Like the famous saying goes, by failing to prepare, you are preparing to fail. And so I think it's extremely important for all in-house legal teams out there to, like all our presenters here today said, record keeping, maintenance of books, and communications are becoming extremely crucial in preparing your first line of defense when that regulatory enforcement notices are received. And that will be the first place that you will turn to demonstrate the manner in which the company strategy and certain actions have been taken. And so it's extremely important that we have our eyes on that. And India has, simply long had the reputation of being a market which lacks stringent law enforcement and robust governance. So regulatory agencies are also fast changing, and the recent increase in regulatory trends is a clear testament to that. So with that, I would like to close the webinar today. Before we close, though, I would like to ask each of you to respond to the poll slide that's on your screen to provide your feedback on today's webinar. We take this very seriously as part of our continuous improvement program. The poll slide is now on your screen. Super. Thank you to everyone that participated in the poll. Finally, I would like to thank all our panel members for sharing their expertise and experience with us today. You were simply outstanding, if I may say so myself. Thank you so much. Also, thanks to you, our audience, for your attention and your questions. I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send to you a copy of today's presentation materials, summary notes, and a link to the webinar recording. You will separately receive a request for your feedback on the webinar. Please do take the time to send us your feedback. Comments, criticism, and even compliments are very welcome. The form takes less than 1 minute to complete, and we'd be grateful for your time on that. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the contact slide here on the screen. Thank you for your attendance today, and we look forward to being with you again at the In-House Counsel Forum.
Thank you.
Thank you very much.